Bueno, eso sí es importante. Quizá necesita micrófono aquí el podio.
Ya tenemos micrófono. Lucía? Yeah, okay. Well, welcome. Good morning, everyone. Bienvenidos todos a Mexico City Investment Arbitration Days and to World Arbitration Update. Before giving before beginning with this panel, which of course is of utmost importance, I would like to give special thanks to all the organizers, because we have been incredibly hosted by the Mexican colleagues and the UNAM. So I would like to give a huge thanks to everyone here, not only by the organizers, but by every Mexican person, whether organizer or not. We have been really been welcomed in the most warm way, and I could not think of a better partner to do the World Arbitration Update forums. As a reminder, the World Arbitration Update forums, and forgive me again, my name is Jose Antonio Rivas, and I'm one of the co-founders of the World Arbitration Update. The World Arbitration Update has two focuses. One is to update on issues of investment treaty arbitration, on issues of international commercial arbitration, and on issues of public international law. And it really started as an anecdote I was sharing yesterday with how it started. We were in the midst of another forum, and a woman very kindly sent me her recent draft, close to being published by OUP, on a topic that is very dear to us, which is fair and equitable treatment. But her book is on fair and equitable treatment from the perspective of developing states. And I read a couple of chapters of that book, and I was impressed. And the next thing was, okay, well, who is this lady? And it happens that she's from Bangladesh. And the next thought was, why isn't she here? Why isn't she being featured in the main international arbitration forums? And it was simply adding 1 + 2 and saying, well, there should be a forum that gives or provides a platform for incredible counsel, arbitrators, diverse individuals from many geographic parts of the world, and not only focusing on Paris, and I love Paris, in New York, and I love New York, and Washington, and of course I love in Washington because I live there, and so on and so forth. Why couldn't we have a forum that gives a platform to everyone who may be, I don't know, in Mexico or Bolivia or in Nigeria, etc., and some parts of Europe which are not the main centers, etc. So that was sort of the inspiration. So one objective of this type of forum is decentralization of international arbitration, and the other part is exit. Now it is impossible. 300 ongoing cases. This is a new medium. We have a library of videos of all the panels. Everything is recorded. And as some news, we're working on an application which is based on having automatic transcripts of the proceedings. So that is for research purposes, for people to watch, and anybody can watch it. Luckily, we have had sponsors, but the other interesting bit of the WOW, or the World Arbitration Update, is that there is no fee for registration. unlike other very prestigious forums. Nobody pays to be here as a student or as a research person. You come, you can watch the video, and that's it. So maybe some might not be happy, but I think that this is the best forum. And yesterday's panels were really incredibly of substance. I learned a lot, so thank you. And with that, I would like to introduce Carlos Humberto Reyes Diaz, who is our moderator. And I must say, Carlos Humberto is a researcher and an academic and a professor, but also a practitioner. He's also an arbitrator. He has more than 20 years of teaching experience in subjects in the area of international economic law. He has taught undergraduate and postgraduate classes at the Faculty of Law at UNAM, in the postgraduate course in law at FES Acatlán, and in the postgraduate course in international relations at the Faculty of Political and Social Sciences, all at UNAM here. He is a CONACT YT level national researcher. He received the National University recognition for young academics in teaching in social sciences in 2007, and he has been a panelist for NAFTA chapter 19, and in 2020 he was proposed on the list of the TECMEC panelists of the commercial remedies chapter. He is an arbitrator on energy issues in the London Court LCIA and the Court of the International Chamber of Commerce. He is also an author and of works in international economic law, both international trade and investment arbitration. And with that, I give you the floor. Thank you.
Thank you very much, Jose Antonio. Really generous presentation. Welcome, everybody. I would like to start by thanking the opportunity to moderate this panel. The University of Mexico and its Institute for Legal Research welcomes you to our second working day of the Mexico City Investment Arbitration Days within the World Arbitration Update 2023. This is one of the best events on investment arbitration worldwide, and Mexico plays a very active role in ISDS proceedings, with many bilateral investment treaties and treaties with investment provisions in force. Mexico, as was said yesterday, is still ranked 6th place as respondent state. This event is a great opportunity to enhance the relevance of the international investment law and arbitration by hosting experts at the highest level. Thanks to the sponsors, RRH Consultores and Bambael Embellis, as well as our panelists here, you, the audience, and all the people involved in the organization for this relevant event. Today, we have a great panel called From Metalclad to Ruby River Capital LLC, Mexico's NAFTA Experience and the Future of Investment Arbitration under the USMCA. 3 international experts, my colleagues and friends, Cindy Rayo, Arista Lopez, and Bernardo Sepulveda, they will address this topic in a little more than 1 hour, a challenging task indeed. We have decided to separate this panel in 3 parts. First, contributions of NAFTA to ISDS arbitration. Second, similarities and differences between NAFTA and USMCA. And third, what is the future of investment arbitration? Let me introduce a few remarks. Is an international arbitrator, trade and investment attorney. Cindy has over 15 years of experience in trade, in services and investment, as well as investment arbitration. She served as deputy and advisor in investment arbitrations for the government of Mexico, where she represented the country in 17 international investment arbitrations under ICSID, NAFTA, and UNCITRAL. Various international trade forums. In particular, she represented in the discussions for the ISDS reform and the drafting of a code of conduct for arbitrators and adjudicators, among others. Cindy also served as counsel and Mexico's lead negotiator in 17 investment agreements. In second place, Arista Lopez is a legal consultant specializing in international trade and arbitration at Clark Hill PLC. Before joining Clark Hill, he held positions at the Ministry of Economy of Mexico, first as Deputy Legal Counsel for International Trade, and later as Legal Counsel to the NAFTA office of the Embassy of Mexico in Washington, D.C. Aristeo served as Mexico's lead negotiator of several investment agreements, including the investment chapters of the US-Mexico-Canada Agreement, USMCA, and the Comprehensive and Progressive Agreement for Trans-Pacific Partnership, CPTPP. Aristeo also counseled Mexico in ISDS cases under NAFTA and the BIT Mexico, Spain. Last but not least, Bernardo Sepulveda Amor is a former judge of the International Court of Justice from 2006 to 2015, elected as its vice president for the period 2012 to 2015. Judge Sepulveda Amor has a wide experience as a presiding arbitrator in cases under UNCITRAL rules, the ICSID Convention, and the ICC rules, as well as an appointed arbitrator in many investment tribunals. Bernardo is of counsel at Krill, a leading law firm based in Mexico City, where he is head of dispute resolution department. Judge Sepulveda Amor has been Secretary of Foreign Relations of Mexico from 1982 to 1988, and Ambassador of Mexico to the United States of America and the United Kingdom. Welcome you all. Thank you so much for being here. Now, to begin our session, I will ask with the topic of Mexico's experience and contributions of NAFTA to ISDS arbitration. For that, I ask Aristeo to take the floor. Please, Aristeo.
Creo que este.
Here we go. Better now. Thank you. Good morning. Thank you very much. And thanks to the UNAM and World Arbitration Update for the invitation. It's a pleasure to see a lot of familiar faces and all colleagues. And I'm really happy about that. And I will say that, I mean, this topic is fascinating because you have to go back to and take a journey to 25 years ago and take a look to the first cases and see how case law has been developed over the years. But I think we have to recognize that to talk about Mexico's experience in ISDS cases and the contribution of the NAFTA case law to the arbitration system, or it will be impossible to do it in 10 or 15 minutes. But I will try to do my best to just emphasize or make reference to a few aspects that hopefully will cover to some extent the most of the 25 years of existence of NAFTA. When NAFTA entered into force in 1994, there was an expectation that Mexico was going to be the party who was going to be facing most of the cases, and perhaps that was the case. But as was mentioned yesterday, no one expected that the amount of case law was going to be developed as we see it today, and that's something that is remarkable. And on that regard, I will start by, I think the starting point here in this in my presentation will be the Metalclad case, which is referred to in the title of this panel. And I think it's a good starting point to talk about the Mexico's experience and participation in NAFTA cases. And now that Hugo is here also, I think he should be doing this part of the presentation as well, because he was the lead counsel in that case. But it's not the first case, even though it's a starting point for his presentation. I have to say that this was not the first case for Mexico. Robert Asinian was indeed the first one. And also Robert Asinian has the merits of being the first dispute to be resolved on the merits under NAFTA. So that's something that goes in history. And also, as Robert Asinian was the first victory for Mexico under the leadership of Hugo Perez-Cano and the legal team and at the Secretary of Economy. So that's that was to be the first experience for Mexico. I think it was a good first step. Now going back to Metalclad, Metalclad has been always it's been subject of many articles, review and discussion, debate. And the reason why mainly is because of the interpretations that provided in the award. I think one of the most relevant will be the interpretation of Article 1105 of minimum standard of treatment. In that case, Metalclad alleged that the lack of transparency by municipal authorities in Guadalcázar, San Luis Potosí, breached the Article 1105, and the tribunal sided with the claim and the concluding that the transparency, this lack of transparency, indeed breached Article 1105. The Mexican government challenged this award before the Supreme Court of British Columbia in Canada, and Mexico made a great job in trying to set aside this award, although it was not set aside completely. I mean, at least Mexico succeeded in setting aside this interpretation of expansive interpretation of Article 1105, and also Mexico succeeded in also setting aside the portion of the award that found expropriation on the basis of on transparency as well. So in the end, Mexico had to pay compensation for this in this case, and it was the second case, and Mexico lost the case, but it was a good example of where things are starting to go in terms of potential wrong interpretations of the NAFTA in the early cases, and that is it. That's it. Also the importance of Metalclad, because it started this trend of wrong interpretations, and NAFTA parties started to be concerned about this. And there are another couple of cases that I think are worth mentioning, because you can understand the context of Metalclad case, and those cases are SDA Myers and Pope and Talbot, which were against Canada. We're not against Mexico, but the potential of the interpretations in Article 1105 continue to be dangerously going beyond what the NAFTA parties intended. And for instance, in SDA Myers, the tribunal determined that the breach of Article 1102, which is national treatment, essentially established a breach also to Article 1105. So again, going beyond what the NAFTA Article 1105, the scope of Article 1105. So by taking this decision, the tribunal took a breach of a conventional international law and equated to a breach of a minimum standard of treatment, which is something that also caused concerns among the NAFTA parties. And the third case in this trilogy is the Pope and Talbot against the governor of Canada. In that case, the tribunal stated, and I quoted, that a possible interpretation of the presence of the fairness elements in Article 1105 is that they are additive to the requirements of international law. So again, this was I guess enough for the NAFTA parties, and that's why they decided to use what I think is one of the very important tool to guard the correct interpretation of the treaty, which is called the Note of Interpretation, adopted by the Free Trade Commission. And this is a tool that has been used just once in the life of NAFTA. There was some attempts to agree on a second note of interpretation at some point, but didn't work. But this in this context, the NAFTA party decided to adopt a note of interpretation on Article 1105. And basically, when you read the note of interpretation, the content of it basically is like a response to those tribunals and saying that basically rejecting what those tribunals had said about the scope of the minimum standard of treatment. So because these notes of interpretations are binding under NAFTA, the tribunals in future cases have to observe the content of these notice of interpretation. So this was a way to correct these expansive interpretations by tribunals. And it also had an impact on the drafting of treaties in the future. For instance, in 2004, the US updated its BIT model, and as you can see, the minimum standard of treatment provision, minimum standard treatment provision was changed and was adjusted to reflect the context of this note of interpretation, and that was kind of the new wording for this standard in future negotiations. So the impact of this note is really relevant for the evolution of the case law under NAFTA. What else can I say? Also, in the case of, and also, I mean, the notes of interpretation has also an impact on cases that were not under NAFTA. For instance, there was another famous case, TECMED. There was another discussion in the tribunal between the parties about the scope of Article 11, the fair and equitable treatment, which is different to what we have in NAFTA. But in the end, the decision in that case was very expensive also as well. And Mexico, after this decision, decided to suggest to Spain to renegotiate the VIT. And the new VIT in 2006 reflected the context basically of the note of interpretation. So they completely changed the view, the standard that was in the VIT with one that is more consistent with what we have in NAFTA. So I think that's another kind of a effect of side effect of this note of interpretation this note of interpretation have in other treaties. And now that I'm mentioning the note of interpretation, I think it's also equally important to mention another component of the note of interpretation, which is transparency. Half of that note of interpretation talks about transparency, and that's something really relevant for NAFTA because NAFTA basically had no provisions on transparency except for the annex, perhaps on publication of awards. There was no provisions on transparency, and for the first time, the NAFTA parties decided to agree on a set of provisions that will make all the information submitted to the tribunals and to make it available to the public. I think that was an important change in the development of case law as well. After that decision, we started to see a lot of information posted in the websites of Canada, the US, and Mexico, and it important contribution that I like to mention, and it's not too often discussed, is a statement by the Free Trade Commission on non-disputing party participation. And I think this is another important contribution because also there was no provision on NAFTA on these family called amicus curiae submissions. So third parties could join could submit written communications to the tribunal. And there was nothing in NAFTA about it. And I think this was an important precedent as well because it set the standard basically for future investment agreements as well. And I think it's worth mentioning. Of course, this statement was not binding as a note of interpretation, the 2001 note of interpretation, but it was a good benchmark for future treaties. And I think that nowadays in the modern treaties, we see it's common to see these type of provisions included in the text of the agreement. So it's a good thing to mention as well. Finally, I would like to briefly refer to another important contribution in my view, that is the non-disputing party submissions under Article 1128. This tool, in my view, allowed also contributed to the development of case law in NAFTA because, for instance, I mean, the respondent party not only was the one who was participating in the case, but also the non-disputing parties were able to present or submit issues of interpretation involving in that NAFTA case, and that. In the early days of NAFTA, it was not a tool very often used, but I will say that after, for instance, in Robert Alcini and Ethical Corporation, the first cases, I didn't see any Article 1120 submission, but after Metalclad, perhaps I started to see like an increment of increase of 1120 submissions. And nowadays, I mean, if you look at any NAFTA cases, and you can see very likely that you will find an 1128 submission by either the US or Canada or both. So this is like it became a practice for the NAFTA parties to participate in every ISDS case under NAFTA. And I think that's a good practice because it's another way to prevent wrong interpretation, even though not always have worked. What else can I say? Well, just to briefly mention, I think the other two relevant cases that I think are relevant that I think were mentioned in this Farmland Fund against Mexico as well. That's a case that I think was the first ISDS case on financial services under a different chapter 14 of NAFTA. And it was in favor, also in favor of Mexico. Also, we will let the team in that case as well. So this is very important because if ISDS provisions on financial services remains to be like treated in a separate way, and that's something that you can see in CPTPP or USMCA that kept the same architecture of design of keeping on a specific set of provisions for ISDS on financial services, and that remains to be the case of today. So I think it's another good contribution of NAFTA. Okay. And finally, the other case that I would like to mention is CPI and ADM, because in these cases, this was the first time what the consolidation article was applied. There was a special tribunal to determine whether these two cases were going to be consolidated. So I think that's another important thing, because that consolidation provision remains to be in CPTPP, USMCA. So it's proved to be worth keeping it. And finally, just make a last comment. All this contribution, in my view, have resulted in from the active participation of the three NAFTA parties, now the US, United States, Canada, and Mexico for some 25 years. But with a bit of nostalgia, I see that this incredible interaction is ending or going to an end. Once all the remaining NAFTA cases under the USMCA legacy clause conclude. But the real legacy will continue through the existence of the other investment treaties influenced by NAFTA. Thank you very much.
Thank you so much, Aristeo. Really very important information concentrated in a few minutes. Thank you. Don Bernardo, a few thoughts on this?
Thank you. Thank you very much indeed. Let me say what a privilege it is to be a participant in this conference in the National Mexican University, the University of Mexico. Not only because of the high quality participants in the conference, members of the arbitral community as a whole, but also because it means an educational process in the case of students in Mexico who may, as a result of this conference, increase their interest in dispute settlement through arbitral means. It's obvious that, as Aristeo has indicated, the treaty itself was NAFTA, a very important instrument in the development of arbitration matters. It has set a precedent of the way arbitral tribunals work, and the decisions of those arbitral tribunals have been most influential in the development of arbitral law. But let me add also that in the case of Mexico, the signing of the treaty itself meant a legal revolution in the domestic sphere, because as a result of the signing of the treaty, we had to modify a number of laws, of legal instruments that there were already obsolete, and that as a result of that, a process of amendments and reforms in the Mexican legislation became an important issue. So a tribute has to be delivered to the way the tribunals applying NAFTA principles have influenced as a whole the evolution of arbitration as a whole. In my case, my task is one that has to do with a comparison between NAFTA principles and USMCA principles. There are similarities, but it's clear that they are not identical. They have important differences, and I will pinpoint one that I regard as an essential one, perhaps as the most important one, not only in terms of what it will mean for arbitration and flow of investment in Mexico, but also the question of the impact, the novel questions that USMCA has in the role to be played in the future of our international arbitration as a whole. Let me start by saying that there is a bridge between NAFTA and USMCA, which is the so-called legacy rule. I will resort to my notes to say that on the 1st of July 2020, NAFTA was terminated as a result of a political controversy. We all know the controversy I am referring to. However, if certain requirements provided in USMCA are met, NAFTA will still apply beyond its termination, but it shall apply only for arbitrations filed between July the 1st, 2020, where that's to say the entry into force of USMCA, until July the 1st, 2023. So that's getting very close indeed. The entry into force of that means three years after the entry into force of USMCA. Now, the important thing is that up to now, as far as the information is provided, there are already 13 cases in which this legacy rule is being invoked. As far as I can know, there are 9 cases against Mexico, 3 against Canada, and 1 against the US. Now, the substantial differences I indicated before are relevant because it is wrongly assumed that NAFTA and the USMCA are identical. They are not. There are essential differences that have to be mentioned. Of course, it is very important to take notice that in the case of Canada, the government of Canada decided not to be part of the ISDS chapter. So that means that basically the US and Mexico are the ones who have the chapters related to dispute resolution on the matter of investment and not Canada. Canada, perhaps for domestic reasons, decided not to join those chapters. The first important difference that I notice in the case of USMCA is the definition of investment. It's interesting to notice, and Aristeo has already mentioned the contributions made by the tribunals to the development of rules in international arbitration, and the definition of investment in the case of the USMCA is an example of that. Let me tell you the reason for that, because it is inspired somehow in decisions of arbitral tribunals. It indicates that that in contrast to NAFTA, it provides a more precise definition of investment, inspired to some extent by decisions of fixed arbitral tribunals. The definition is the following: every asset that an investor owns or controls directly or indirectly will be considered as an investment. But additionally, that has the character that investment has the characteristic of a commitment of capital or other resources. And third, the expectation of gains, of profits, or the assumption of risk. We may all remember the decisions that have been taken by arbitral tribunals defining these elements in investment. Of course, also USMCA includes many other items that are somehow similar to ones NAFTA provides, but are not necessarily identical in all cases. The question that is far more different and that signifies somehow an abandonment of certain rules in arbitral principles is the so-called covered sectors that are included in the USMCA. That is not a novelty. In my knowledge, there is no other treaty that provides a similar treatment as the one included in the USMCA. Under this treaty, a privileged group of US or Mexican investors, not Canadians, not Canadians, who possess a covered government contract and that operate in a covered sector enjoy a strong and extensive protection in terms of both procedure and material investment claims. To qualify as a member of this elite group of investors, the investment must operate in one of the 5 covered sectors, which are the following: oil and gas activities, power generation services, telecommunications, transportation services, infrastructure. But all other sectors are excluded. I will mention that later on. Investors with covered government contracts benefit with a series of substantive rights, such as the following: a minimum standard of treatment, which includes fair and equitable treatment and full protection and security. protection against direct and indirect expropriation, and exception from the requirement to exhaust local court proceedings as a prerequisite to resort to investment arbitration. It is indeed a very privileged situation. Those investors not belonging to the covered sector will have under USMCA a less substantial protection in their rights than the one they have under NAFTA. Their claims will be limited to invoke a breach of national treatment, recourse to most favored nation treatment, and the possibility of a claim of expropriation. But by the way, only direct expropriation, not indirect expropriation. That may happen only after these investors first successfully exhaust local remedies as a requisite to initiating investment arbitration procedures. Beyond the legal reach, they will not be able to claim a violation of fair and equitable treatment or the existence of an indirect expropriation, as I indicated before. So USMCA considerably limits the scope of the notion of national treatment by providing that in determining whether a foreign investor is afforded national treatment, and it is another important qualification, a so-called like circumstances applies, which means that the decision to allow national treatment will depend, and this is what the treaty says, on the totality of the circumstances, including whether the relevant treatment distinguishes between investors or investments on the basis of legitimate welfare objectives. So this means a highly flexible interpretation that can be applied on this issue of like circumstances. It's an interpretation that will be provided perhaps to the national government. Additionally, USMCA, as I said before, explicitly excludes indirect expropriation. After noticing some of the dramatic differences that appear in the comparison between the NAFTA rules and the USMCA rules, it is not an easy task to explain and justify the introduction of a privileged scheme that substantially benefits the investor and their investment included in the 5 covered sectors in obvious detriment of the incentives and rights that other investors operating in other sectors of the economy system could be entitled to claim. I will just want to say that it's too early to know how USMCA will be applied and interpreted by tribunals. We still have not a single case that resorts to this treaty, but the proof will come once the flow of investment starts to come under USMCA, and perhaps the fact that the 5 sectors have that privilege, it may mean that there will be a larger amount of investment in these 5 sectors, but perhaps in detriment of the amount of investment that may come in those sectors that don't have the privilege of being covered by the covered sector. Thank you.
Thank you very much, Bernardo. Cindy, Bernardo just referred to some similarities and differences from NAFTA and the USMCA. What are your thoughts on this topic?
Okay, good morning to everyone. First, I would like to thank UNAM and the organizers for having me today. It's a great honor to share this panel with friends and colleagues. Well, I think that Bernardo and Aristeo have said a lot of the difference and the influence of NAFTA in the USMCA. So I'm going to focus on other differences that I consider also that are very important. But first, I want to start my intervention giving a historical context of the investment chapter, because it is important to take this into account to understand what the outcome of the chapter 14 of the USMCA. And during the negotiations, the USMCA, the political context, the economic as well, influence the discussions and the future of the investment chapter. During that time, the CETA was recently negotiated by Canada with the European Union, and Canada established for the first time an investment court, also influenced these negotiations. For instance, one important feature of NAFTA is the ad hoc arbitral system, and this was under and the negotiators had doubts about the functioning of this system. And also, when the negotiations started, the US were considering and questioning very seriously the ISDS. The politicians in the US, as well as the trade representative, does not like the ISDS. They consider it is as problematic, and they also view as it violates the US sovereignty. So at that time, US did not have any text. Canada was proposing something similar about the CETA, and Mexico maintained the traditional approach during the negotiations, and also an opt-out discussion or approach were also in the discussions. I think that this context will help to explain the outcome of the investment chapter. And Aristeo did a very good job on explaining how the NAFTA case law influencing the USMCA, and most of the USMCA provisions in the investment chapter, including the ISDS, were influenced by the case law and also by the TPP, then the CPTPP investment chapter. So I will say that in many aspects, the USMCA investment chapter is an update of the investment chapter in the NAFTA. I'm gonna mention very generally about for example, in the substantive provisions, the USMCA preserve and improve most of the substantive provisions of the NAFTA, such as national treatment, expropriation, MST. Ambassador Bernardo already mentioned the national treatment provisions, where the parties decided to give some clarity about the meaning of like circumstances, and there is a specific language to give clarity on for greater certainty on what is the meaning of like circumstances. Also on expropriation and MST, the influence, as Aristeo mentioned, of the case law in these provisions was substantive. I just want to mention that, for example, in annexes 14A and 14B, those annexes bring clarity to the substantive provisions. These annexes contain the common understanding of the parties about the meaning of customary international law, about the meaning of what is expropriation, and on what constitutes direct and indirect expropriation. In addition to these provisions on the substantive section, there were also new provisions such as the corporate social responsibility provision to encourage the enterprises to adopt internationally recognized standards such as the guidelines of the OCDE. And this provision comes from also other treaties that Mexico have on the Pacific Alliance Framework Agreement and also on the CPTPP. So the protection, in sum, the protection is very similar as under the NAFTA, but procedurally, the rules are substantially different from NAFTA. And Ambassador Bernardo have already highlighted those main differences. So I'm not going to enter into the details about the legacy claims, just to mention that on July 21st, 2023, ends the time frame for bringing claims under the Chapter 11 NAFTA, and there are two main requirements for doing that. One is that the investment must be have been established during the lifetime of NAFTA, and the second that they had to submit a notice of intent 90 days before the July 1st of this year, and this deadline have already expired. So another important difference is that despite the fact that the standards of protection to investors and investments apply to the three USMCA parties, in the ISDS mechanism, as it was mentioned in previous panels and in this one, does not apply to the three parties. Canada, the USMCA does not apply to Canada, so disputes should be resolved under the CPTPP. Entering into another main differences, I would like to highlight that most US investors in Mexico lose the meaningful access to the ISDS, and one of these changes is the exhaustion of domestic remedies. This means that they have to first litigate in domestic courts the case before submitting a claim under the USMCA. And another important change is what Ambassador has already mentioned, that only covered investors that are in the key covered sectors that you have already mentioned, with a covered contract, of course, can bring a claim for all the substantive provisions, and do not have to litigate it in domestic court. It is an important point. And for those investors that are not under the covered sectors or covered contracts, investors only can bring national treatment claims and for direct expropriation, no indirect expropriation. And another procedural changes is that the procedural rules applicable to arbitration are now extended to any agreed by the disputing parties. And also the restriction to use the UNCITRAL arbitration rules from 1976 in the NAFTA was changed and now is flexible, so the parties can may choose to apply the more recent versions of those rules. For some claims, for example, the statute of limitation was increased from 3 to 4 years. This is another important change. And there were concerns about the independence and impartiality of arbitrators. arbitrators. So with that aim, there was included a provisions incorporate the USMCA incorporated the International Bar Association guidelines on conflicts of interest. And it also contained a double hearing rule, which establishes the provision to act for the duration of the proceeding as a counsel or as a party appointed expert or witness in any of pending arbitration under the annexes of the chapter. And another important improvement of the agreement is the inclusion of the transparency rule. Aristeo has already told about the case law and the importance of this principle. And most of the NAFTA cases were relied on the maximum principle of transparency of the arbitral proceedings, and this was reflected in the USMCA, which provides that all the arbitration hearings and the documents were available to the public. Another important difference is the and recognizing the importance of the amicus curiae. USMCA included rules to ensure that interested stakeholders, including labor unions, civil society, and organizations, can submit amicus curiae or friends of the court briefs. And finally, to close this intervention, there were some provisions about the discontinuance of proceedings. If the disputing parties, for example, fail to take any further steps in the proceedings for more than 150 days, it proceeds the discontinuance of the proceeding, and this is due to the fact that Mexico has already faced some cases where the investors submitted a notice of intent, but they don't take any further steps for many years. So this is an important provision to avoid those kind of abuse of the system. And finally, there were other improvements on interim review stages. And this means that at the request of a party or a disputing party, the tribunal may, before issuing the award, may review or transmit its proposed award and the decision to the parties. So those are some of the main examples and differences that are and the updates and improvements from NAFTA to the USMCA. Thank you.
Thank you very much, Cindy. We have a few minutes left, and I want you to give us, every one of you, a few minutes to address about the future of the USMCA, especially a precision dart maybe on whether US, Canadian, and Mexican investors will still have access to investment arbitration under the USMCA. We have a few minutes, so please, Aristeo, what do you think about this?
Yeah, works now. Okay. Thank you, Carlos. Well, the short answer will be yes. I mean, Canadian investors will be still available to file SDS claims against Mexico under the CPTPP, not the USMCA. Now, about the final comments on the future of arbitration in the region. I mean, I would say, putting aside a little bit the discussion of arbitration, I would like just to mention the case for Mexico, because Mexico has now agreed or negotiated like a different set of different investment provisions. We have, someone mentioned, we were discussing yesterday the Brazilian model. Mexico was the signatory of one of those agreements with Brazil. We have the CPTPP model, to say so. The USMCA with this unique annexes. And then we have the treaty with the European Union, which even though it's not still enforced, provides like a different approach to ISDS. So the question here will be, what is going to do Mexico the next time they decided to negotiate an investment agreement? They have like a full range of options. I don't see going in favor of the Brazilian model, to be honest with you. I think it is the natural flow will be going to something more similar to CPTPP, because it's kind of the natural evolution of NAFTA. The question about the permanent court approach by the European Union, I think, is still under a lot of debate. So it's important to me to see what's going to be the next step for Mexico. There has been not a lot of action in that side of negotiation side. It seems that Mexico is not doesn't have the urgency to do that, but let's see what the future brings. Okay, thank you.
Bernardo, do you agree?
Thank you very much. I think that the issue that bothers me most is the one related to the covered sectors in the future. By that, I mean the possibility that there will be a discouragement on the part of some investors, and I'm thinking of US investors, because they will not have the same protection that the covered sectors have. That may mean a restriction that will mean a disincentive to invest in Mexico, because more obstacles are provided for in the case of the ones not covered by the covered sectors than the privileged ones. So it may happen that, for example, in the case of the mining sector, which is one that is being excluded from the full protection, let's call it that way, or issues related to public health, issues related to education, and other sectors that may feel that they are at a disadvantage vis-a-vis the potential breaches of rules by the authorities, and that their capacity to resort to arbitration will be very much limited. Their situation is even worse than the one NAFTA provided. I mean, NAFTA provided a very substantial set of rules in order to protect all foreign investors in Mexico coming from the US and from Canada. In the case of the new treaty, that doesn't happen. That protection for those that are not privileged is far more elusive and restrictive. So I wonder how much the flow of investment will come to Mexico as a result of these fears the non-covered sectors may have, and that the resort to arbitration may mean for those non-covered sectors something that is no longer as attractive as it used to be in the case of NAFTA. Thank you.
Thank you so much, Bernardo. This is a very controversial measures of the USMCA, Cindy. What do you think about this future in the special case of US, Canadian, and Mexican possibilities of access to have access to investment arbitration under the USMCA?
Well, I will say three main things. The first one is that we should have in mind that in 2027, we will have a revision of the USMCA. And the USMCA will be subject to a revision by the three parties to decide whether they want to extend the term of the agreement or to terminate it. So from my perspective, many issues will be at the stake in the revision. The political, the commercial, the rise of the investment claims, of course. And this rise of investment will depend on to what extent the controversial issues that are taking part of the agenda of the two countries during the last years on many issues be resolved. And also the effectiveness of the mechanisms to resolve these controversial issues. We should have to remind that the USMCA negotiations were influenced at that time by the political, the economic, and the commercial context. So it is very likely that the same will happen during the revision of the agreement. Another front or another important thing is the populism in Latin America and in many of our countries. This makes more necessary to provide certainty, stability, and mechanisms to enforce the rule of law at the international level. This is something that was discussed yesterday in the last panel. And this is also very important in a context of nearshoring, friendshoring. So we need near trusting in doing business. And I think that this is an aspect that also will influence these discussions. And finally, I would like to highlight the discussions that are taking place in the UNCITRAL Group 3. There were discussions about the lack of coherence of arbitral awards, lack of independence and impartiality of arbitrators, the duration and cost of arbitration arbitrations. So under this group, there were many concerns raised by the states, and there also discussions about the reforms to resolve these concerns of states. So we should follow the outcome of these reforms and be very put a lot of attention on whether this outcome or the outcome of this discussion will really achieve the expectations of states due to the several concerns that were raised by the states. I want to highlight that recently in the last meeting in New York, was approved the first outcome of the group. That is a great achievement, the code of conduct of adjudicators. I congratulate McKinner, who was also part of that discussion, because it was something that was done between UNCITRAL and the ICSID. So from my perspective, those are the main aspect that we should be very pending and to put a lot of attention. And I think that will, of course, those will influence the future of ISDS in the region. Thank you.
Thank you so much, Cindy. Unfortunately, time is implacable and we are out of time right now. But before we finish, I want to thank the three of you for the very interesting approach to this topic, very complex topic. And thank you all for the session. I believe we have a brief recess of 10 minutes maybe, and we follow to the second panel of the day. Thank you so much.